against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and reach a true verdict. If religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Would you all please stand? Oh, you can all be seated. Sorry.
Please raise your right hand. Each of you, do you solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court, so help you God?
Now you may be seated. And if you turn to page 3 of the information you've been given and follow along with me as I read, those are the instructions. So start at page 3. I will now explain some of the legal principles you will need to know and the procedure we will follow in this trial. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a carefully considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes an opening statement, or he may wait until later. These statements are not evidence. They're only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has a right to cross-examine the prosecutor's witnesses. After the prosecution has presented all of his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has a right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, these are not evidence. They're only meant to help you understand the evidence and how each side sees the case. You must base your verdict only on the evidence. You've been given a written copy of the instructions I am reading to you. You may refer to them during the trial. Since no one can predict the course of a trial, these instructions may change at the end of the trial. At the close of the trial, I will give you a copy of my final instructions for your use during deliberations. The defendant is charged with transporting a female for the purpose of prostitution. To prove this charge, the prosecutor must prove both of the following elements beyond reasonable doubt. First, that the defendant transported, caused to be transported, or aided or assisted in obtaining transportation into, through, or across this state for a female for the purpose of prostitution. Second, that the defendant did this knowingly and intentionally. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances and evidence. My responsibilities in the trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the case, the facts of this case. As jurors, you are the ones who would decide this case. Your responsibility is to decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and all the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. When it is time for you to decide the case, you're only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may be to think about these questions. A, was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? B, does the witness seem to have a good memory? C, how does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? D, does the witness's age and maturity affect how you judge his or her testimony? E, does the witness have any bias or prejudice or any personal interest in how this case is decided? F, have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? G, in general, does the witness have any special reason to tell the truth or any special reason to lie? H, all in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the parties asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason will be to ask about things that may not have been fully explored. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these questions or objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you're in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the other jurors are there. When the trial is over, you may, if you wish, discuss the case with anyone. If I call for a recess during the trial, I will either send you back to the jury room or allow you to leave the courtroom on your own and go about your business. We must not discuss the case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop and explain that as a juror, you are not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. You must not talk to the defendant, the lawyers, or the witnesses about anything at all, even if it has nothing to do with the case. It's very important that you only get information about the case in court when you're acting as a jury and when the defendant, the lawyers, and I are all here. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth and the parties must be able to cross-examine them. Those news reports do not have to meet these standards. They could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. The restrictions I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Now that many jurors have easy access to information through handheld devices and other technology, jurors may be tempted to use these devices to learn more about some aspect of the case. But if a juror were to do this, it would harm the parties. The parties would have no way of knowing whether the juror has gotten outside information and would have no chance to object to that information was false, untrustworthy, or irrelevant. Remember, no matter how careful and conscientious news reporters, family members, friends, and other people outside the courtroom may be, information about the case from television, radio, the internet, and social media will inevitably be incomplete and could be incorrect. Please bear these things in mind as I read the following instructions. These restrictions apply from this moment until I discharge you from jury service. You must decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that during the trial, you must not read, watch, or listen to news reports about the case, whether in newspapers, on television, on the radio, or on the internet. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, computers, cellular phones, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. Before your deliberations, you must not discuss the case with anyone, even your fellow jurors. After you begin deliberations, you should discuss the case with your fellow jurors, but you still must not discuss the case with anyone else until I discharge you from jury service. Until I have discharged you from jury service, you must not share any information about the case by any means, including cellular phones or social media. If you discover that a juror has violated my instructions, report it to my law clerk. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. You must turn them over to my law clerk during recesses. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see we've chosen a jury of 14. After you've read all the evidence and my instructions, we will draw lots to decide which two of you will be dismissed in order to form a jury of 12. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial, and at the end of the trial, I will give you detailed instructions about the law in this case. You should consider all my instructions as a connected series. Taken all together, they are the law you must follow. After all the evidence has been presented and the lawyers have given their arguments, I will give you detailed instructions about the rules of law that apply to this case. Then you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It's important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that you may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, where you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. And at this time, Mr. Babcock, you may give your opening statement.
Good morning again. I would like to thank each and every one of you for participating as jurors for this case. I understand and appreciate that the fact that each one of you probably would rather be somewhere else. So I will do my very best to present the people's case against the defendant as quickly as possible. I don't believe this case is going to take too long to present the evidence. What happened is that on or about April 27, 2018, the Michigan State Police conducted a traffic stop here in the city of Saginaw. Trooper Cirillet, who's seated at the table with me, was one of those troopers that day. And he'll be discussing and explaining to you what he observed that day, who was present in the vehicle. I believe the testimony will be that he'll indicate that both the defendant, Mr. White, as well as Megan Stinger were in that vehicle that day with Mr. White operating that vehicle. We'll also be calling Ms. Stinger, who was the other occupant. And you may not like what I'm about to say, and I take no pleasure of sharing this information, but it is important to explain what happened on that day, our theory of the case, that is. I anticipate you will hear testimony from Ms. Stanger that she struggles from drug addiction and had in fact had a drug habit back in April of 2018. And I also anticipate that she will testify that the reason that she was in the car with Mr. White on that day was so that she could go back to Mr. White's residence with the express and intent purpose of her exchanging sex for drugs. In other words, she would provide sex. It's going to be, I anticipate Ms. Stanger is going to testify that she was going to provide the sex, and Mr. White was going to provide the drugs to her. The judge, as again, under Michigan law, it is unlawful for an individual to knowingly transport another person into, through, or across this state for the purposes of prostitution, which again is what we believe is exactly what happened here. Sex being exchanged for drugs. It is important to note that transporting an individual any amount of distance is sufficient for the crime to be committed. As an example, picking up an individual along the side of the road and driving around the corner for the purposes of exchanging sex for drugs or money for that matter is sufficient to constitute the crime that Mr. White has been charged with. I respectfully submit, ladies and gentlemen, that the minute Ms. Stanger entered into Mr. White's car and it began to move, that the crime was committed and that it continued to be committed up to and at the time of the traffic stop that you will be hearing about here today. Again, I anticipate Ms. Stanger will testify as to what happened and how she ended up in that vehicle. The people do not dispute the fact that the traffic stop at issue here prevented Mr. White from exchanging sex or drugs on the day in question. The fact that Mr. White may have been unsuccessful in reaching in obtaining sex or drugs is, in my opinion, completely irrelevant. Michigan law does not require the sexual act to have occurred, and Michigan law does not require that an exchange of drugs or money for sex actually occur for this particular crime. The people are only required to prove beyond a reasonable doubt that the defendant knowingly transported Ms. Stanger in Saginaw County for the purpose of eventually engaging in a transaction pertaining to prostitution. That is what we're here for. That's what we're here for today. It is also irrelevant that Ms. Stanger was in the vehicle voluntarily.
Mr. Babcock, can you give me a closing argument or opening statement?
I will move on, Your Honor. Thank you.
Okay.
Again, I would only ask that the court, that the jury, that you only concern yourself with why Ms. Stanger was riding in the car. After all the evidence is presented, the people respectfully submit that you will find beyond a reasonable doubt that the reason that Mr. White had Ms. Stanger in his vehicle and transporting her in Saginaw County was for the purpose of taking her to a destination to exchange sex for drugs. People respectfully request that you find the defendant guilty as charged. With regards to the reasonable doubt standard, again, the judge has already has provided instructions with that, and I would ask that you consider those instructions very carefully. I would like to thank each and every one of you for your patience during this process, and hopefully we'll all be able to wrap this up fairly quickly.
Mr. Neal, do you wish to go opening statement or reserve?
Thank you, Your Honor. At this time, we reserve our right to make the opening statement.
All right. Ladies and gentlemen, we are going to break for lunch right now. Caution you once again not to discuss the case among yourselves, not with anyone else. And should there be any news reports about this trial, do not read, listen to, or watch them. Have a pleasant lunch. We will see you back here at 1.